Well, let me first thank those that have joined for the League Supreme Court Update webinar. I know many of you who are online, but in case you don't know me, I am Jared Tingey. I'm the legal director for the League of Cities and Towns, and I previously worked in West Jordan City for a few years, and then before that in Duchesne County. So um, I hope that this webinar can be helpful for you and your cities and towns as they navigate these cases. As a reminder, I, I really will only be covering those cases that I think have an impact on local governments in some way. Some have more of an impact than others. Um, so before we begin, a few items of housekeeping here. Um, the first, if you are seeking to obtain CLE credit for this webinar, please type in the chat box your name and bar number. And if you're participating only by audio, please just email me at jtingy@ulct.org, preferably by 5 p.m. today, although we can make multiple submissions. So the second thing is if you have any questions, please feel free to type them in the chat box, and I will try to answer them at the end of the presentation. The third being that most of you have city or town attorneys or have contracted with someone to give you legal advice. So here comes the disclaimer. This does not create a attorney-client privilege or a attorney-client relationship, and go to your attorneys for legal advice if you have any questions. I will not be the one defending you in court, right or wrong. So, and also, just for, we encourage you to participate in upcoming ULCT events, including our Legislative Policy Committee on August 19th, and our annual convention in Salt Lake City on September 4th and 5th. We'd also encourage you to sign up for the ULCT emails. Email is really the primary way we communicate with our members. And then also just sign up for Friday Facts. Lastly, these slides in this recorded webinar will be made available to you after the presentation. So that's now that we've got that out of the way, let's dive in. So let me first start with two similar cases that I've lumped together. The first being O'Connor-Ratcliffe v. Garnier, and the second being Lind v. Freed. They both involve similar fact patterns and address the same question. So the question is, when is someone acting as a public official, and when are they acting in their individual capacity? I have these two pictures on the screen, and because there's an argument to be made that the picture on the left is not Voldemort, but is actually Ray Fiennes, just with makeup on. That he has not changed at all. And so when is he Voldemort, and when is he Rafe? And that's really what it comes down to. When do these roles actually come into play? So starting off with O'Connor-Ratcliffe v. Garnier, many of you as elected officials have run into a citizen that is just unhappy and won't stop pestering, regardless of whatever you do. And in the O'Connor case, two school district officials had just that. They used a public Facebook and Twitter accounts as a way to reach out to voters to try to get elected. And after they were elected and won, they continued to use those same Facebook and Twitter accounts and describe themselves as government officials and put their actual positions as school trustees on the page. They were the only ones that could actually used the accounts to post information, and Garnier really became a thorn in their side, and fired off 42 separate posts and 226 identical replies within a 10-minute span, among others. And initially, the trustees began deleting these comments, but eventually they blocked them altogether. And Garnier sued under Section 1983 of the United States Code. And if you're unfamiliar with what that is, that allows private citizens to sue if one of their civil rights they enjoy under the Constitution or the amendments have been violated. The First Amendment protects individuals from actions by the government that restrict their right to free speech. First Amendment does not apply to private citizens or businesses limiting others' free speech. So the argument that Garnier was making is that the school district officials were no longer acting in their personal capacity, but in their public capacity when they deleted and then altogether blocked Garnier from commenting. So if the court were to find that at the time they restricted Garnier's speech, they were also at that time acting as a public official, then it would be a violation of their First Amendment rights. If the court found the other way, that they were acting in their personal capacity, then they would, any sort of deleting and blocking would be just fine, because it would be in their personal capacity. And so the district court let the parties proceed, and the Ninth Circuit of a court of appeals agreed with the district court on a summary judgment motion. And the Supreme Court directed the lower court to the Supreme Court's recent decision in this other case, Lindke v. Freed. So I wanted to switch over to that, and then we'll get to the very end of what happened there. So in Lindke v. Freed, just like the school district officials, Freed set up a Facebook account before he was even elected. Because he was apparently such a popular guy, he maxed out on his Facebook friend number and needed to create a page so that he could have more Facebook friends. I say whatever floats his boat. He later was appointed to be Port Huron city manager and added that position to his page. And a vast majority of the content that he posted was of a personal nature. A daddy-daughter dance, and walking with the family, posting Bible verses, things like that. Occasionally, he would post public information or link to the city website. And during the COVID period, Lindke began commenting on Freed's Facebook about how poorly the city had done and handled the COVID pandemic. And much like the school district officials, Freed deleted comments and then that were offensive, and eventually blocked Lindke altogether from posting. And to be expected, Lindke did the same thing as Garnier did, filed a Section 1983 claim, and said that his free speech was being blocked. So again, it comes down to, was Freed acting in his private capacity and on his private Facebook, or was he acting as a public official at that time? So the court came down with this guidance. They held that in Lindke, that in order for a public official to be an action of the government in regards to social media accounts, the government officer or employee had to have actual authority to speak on the government's behalf. So let me just stop there just for a second. The there's two other important points underneath that first requirement, and that is, first, the authority to speak on the government's behalf can come from law, regulation, ordinance, or even long-standing custom. So if your Public Utilities Division employee has always been that person to post on social media about water breaks or official notices that water will be turned off by the city, then they may be considered to have actual authority, even though it does not say that actually in state code or city code or anything like that. The second important point underneath the first requirement is that the actual authority needs to be specifically related to the speech that is in question. So your public works director would likely not have actual authority to act on the government's behalf related to code enforcement, say, or new businesses in town. So that is the first element to be considered state action. But there is that second one there. The officer employee has purported to exercise that authority when they speak on social media. So let me give a good example. So the court considered this hypothetical to explain this case. They said, consider a school board president announces at a school board meeting that the board has lifted pandemic-era restrictions on public schools. The next evening at a backyard barbecue with friends whose children attend public schools, he shares that board has lifted the pandemic-era restrictions. Well, the former is state action taken in his official capacity as school board president. The latter is private action taken in his personal capacity as a friend and as a neighbor. While the substance of the announcement is the same, the context, an official meeting versus a private event, is very different. So he invoked his official authority only when he acted as the school board president. So each case will be very, very fact specific and fact driven. For a little guidance, the court said the most important considerations are the post content and the function, what they're trying to accomplish. So reposting of city business or directing to a link to the city's webpage is going to be very different than making a declaration under authority of city ordinances. Since the content of the post and the function matter, if you delete a comment of a post that is personal in nature, it won't be as big of a deal as if you block altogether comments from a particular user, because you are blocking not only private but potentially public speech as well. So the key takeaways: resharing public information likely will not be considered public action. On your private social media account, use labels. This isn't an official page of Cam City. And then specifically define in your job descriptions what authority employees have or don't have. The next one is prohibit the use of government logos, email addresses, and websites to be on personal accounts. And the last one, prohibit the use of public property to manage or use private accounts. Don't allow computers or anything like that to be used to get onto private accounts. The next two cases actually also deal with First Amendment speech issues, but addresses a slightly different issue. So we're going to talk about those as well, those in conjunction as well. The next two cases, Murthy v. Missouri. In that case, federal agencies and employees of those agencies publicly and privately requested social media companies, especially Facebook, to take down alleged misinformation related to COVID-19 and elections. You may have heard this one, the facts of this one already, but pretty soon those emails were sent to Facebook to tell them to comply or else some action might be taken. Didn't define what that action might look like. The purpose of the appeal and the issue in the case is really, can legitimate government speech cross the line over into unconstitutional censorship based on demands by the government to these private entities? In other words, can Facebook become a government actor if the government is threatening consequences if they don't remove information from its platform? So, what did the Supreme Court say? Yeah, pretend the guy in blue is the court. Instead of actually analyzing the parties' arguments, the court avoided them altogether and stated that the plaintiff did not have standing or the right to receive a remedy or injunction. I think it was some mental gymnastics, personal opinion, but that's what the court did. In the next case, though, there is some guidance. In NRA v. Vullo, the New York Department of Financial Services began to investigate NRA-endorsed insurance programs that essentially allowed someone to be insured on the use of a firearm, even if that firearm was used for criminal purposes, to commit a crime. So, sounds like a pretty good insurance policy to me. So Vullo, who was the head of this organization, promised certain insurers that she would overlook certain deficiencies if they dropped coverage of this type of insurance with NRA members, essentially. And so the court, this is what the court held. The First Amendment prohibits government officials from wielding their power selectively to punish or suppress speech, directly or through private intermediaries. So there's nothing here that prevents local governments from condemning views which they don't agree with. That's not this case. This case really comes down to stopping someone's speech on the basis of coercive threats. And there's some guideposts to look at here. The court said if we look at the word choice and the tone of what's being said, the existence of regulatory authority, whether the speech was perceived as a threat, and whether the speech refers to adverse consequences. So the key takeaways here is be aware of the tone and content of the speech you're using. Frankly, I don't see this being a problem, but just be aware that veiled threats to accomplish city goals is just, even if those goals are going to do good things, is not worth it. But again, I just don't see this as an issue. The next case we'd like to go over is Gonzalez v. Trevino. I have to admit, this one kind of makes me laugh. Bless her heart. She's the lady to the left there, and she runs on a platform that she's going to remove this currently sitting city manager, Ryan Rapalai, from office. And so, given their current form of government, they have a 2-day public hearing to listen to residents on whether they think this city manager should be terminated. And during the public hearing, residents started to put a little bit of pressure on Sylvia and say that she misrepresented when she stopped by to have signatures on the petition, and she began to be a little bit uneasy. And at the end of the 2-day public hearing, the mayor there on the right side, Edward Trevino, asked for the petition, which is under law is supposed to stay with and remain with him, so that he could give that to the recorder's office. And asked Sylvia whether she had it, and she claims, no, I don't have it. And so the mayor says, well, let me have an officer go and press her a little bit more on that. So the officer goes up and asks her about it, and she says no. And he said, well, open your binder. Let me just see in your binder just on accident. And so she looks through it, and she gets right to where she stuck it into her binder and stops. And lo and behold, they see it, and she acts very surprised. So I think that you'll be able to hear the audio on this. This is, on the right side is Gonzalez. In the middle is the mayor. And that paper, she's about ready to sit down. That's the petition. She grabs it and flips through it, puts it underneath her binder, and that's the mayor's binder that he's grabbing right there. And so she takes it, and in the case they go over a little bit more facts, and it is very clear that she meant to take that and have it be a lost document, essentially. So what happens to her? She, lucky for her, she gets to spend a night in jail. The mayor has the police department look into it, and she's charged with an anti-tampering law that prohibits a person from intentionally removing a government record. And about a month later, the city prosecutor dismisses the charges, and she ends up suing for retaliatory arrest based on her First Amendment rights to protected speech. But then she admits that there's probable cause for her arrest, which was a big mistake on her part. She claims that the criminal statute, though, has not been used to criminally charge someone trying to steal a government document in over 10 years. So this has to be a retaliatory arrest. So the court begins to look at a case that was decided, Nieves v. Bartlett. Now, the rule is that if there's probable cause to arrest, then that retaliatory arrest claim has to be dropped because there was original probable cause to arrest. The exception, though, to that is that even if there is probable cause for the arrest, if the plaintiff can show objective evidence that they were arrested for a crime, that others were similarly situated that were not arrested, then you can use that to continue forward the case and continue your retaliatory arrest Fourth Amendment claim. So take, for example, jaywalking. I don't think it's an offense that is very often charged. And if someone takes or tells the police officer how much they hate them and law enforcement and that they're doing a horrible job, and then they are arrested for jaywalking, he or she may have a good claim for retaliatory arrest because it usually isn't charged. The issue, though, is that the argument back was, well, she didn't show that. She showed that it wasn't charged in a long time, but she didn't show that that a council member in the past was not charged with withholding a petition and lying to an officer, and so the court made this distinction that there doesn't need to be a specific fact pattern to show objective evidence that that you're being retaliated against. So what does this do? If you do illegal things, make sure there's not a video camera over your head. Second, the past history of enforcing or not enforcing laws could be used against you in the future. The third one, if there are unused criminal laws that are never enforced, don't all of a sudden enforce them based upon someone's comment that you don't like, because it could come back and because it's not charged very much, or others charges are dismissed that way, you could very well end up in a bad situation. Obviously, make sure there's probable cause before arresting, and if there is probable cause, be consistent in your enforcement. Don't, just be consistent, whatever that may be. The next case, United States v. Rahimi. It's a case about a violent man who assaulted his girlfriend, was issued an order by the court, a restraining order, that said he couldn't have any guns during the time that the restraining order was in effect. And then he decided that it would be a good idea to go and commit 5 different crimes with that gun. The statute here prohibits any person from possessing any firearm or ammunition if they are subject to a court order that includes a finding that such person represents a credible threat to the physical safety of an intimate partner or child. And Rahimi sued, saying that statute violated the Second Amendment. He should be able to hold a gun at any time for any reason, even though he was under this restraining order or that he was a felon. The court came back and said, well, the Second Amendment doesn't come without limitations. An individual found by a court to pose a credible threat to the physical safety of another may be temporarily disarmed, consistent with the Second Amendment. The key takeaways here, the court only determined that the federal law on its face did not violate the Second Amendment. It didn't state that it could be unconstitutional as it is applied in certain situations with certain people. So someone may have a good claim under this statute that there is no credible threat that they are in danger to anyone. And in that case, the result may be different, to say that in that particular instance, it is unconstitutional. So it, just because it on its face, it wasn't unconstitutional, it could be, as applied, unconstitutional. The next case is a big one for cities. Grants Pass v. Johnson. This involves the subject of homeless camps, encampments, and what cities can do or not do as it relates to those homelessness camps. There's challenges that are brought up, and as you can see here, many different headlines that a lot of different cities are working through to come to how do we help the homeless population. And so the facts of Grants Pass here. Grants Pass is a city in Oregon that has a population of about 38,000 people, of which on any given day there's about 600 homeless individuals. And Grants Pass adopted a few no camping ordinances And the first prohibits sleeping on public sidewalks, streets, or alleyways. The second prohibits camping on public property, and the third prohibits camping and overnight parking in the city parks. Camping is defined there as setting up or remaining in or at a campsite. And campsite is defined as any place where bedding, sleeping bags, or other material used for bedding purposes, or any stove or fire is placed for the purpose of maintaining a temporary place to live. They also set up a series of steps for enforcement. The first, if you were caught violating any of these no camping laws, Grants Pass had a series of enforcement. The first offense being a fine, the second offense being barred from city parks, and after that, you could be charged with criminal trespass and also a fine up to $1,250, and could result in 30 days in prison. The court, the issue at hand is, does the Eighth Amendment Cruel and Unusual Punishment Clause restrict state and local governments from regulating camping on public property? A few homeless individuals filed that lawsuit, and the court mainly relied on a discussion over a Ninth Circuit case called Martin v. Boise as support. Well, that's the case that was supported by the homeless individuals who filed suit, that they had a claim. And the court analyzed Martin v. Boise, which the Ninth Circuit basically barred Boise from enforcing its public camping ordinance against homeless individuals who lacked access to alternative shelter because of the Eighth Amendment. And the key points, though, in Martin were that, or that they pointed out, the Supreme Court pointed out, were troubling in Martin, were the reference to access and alternative. If there were more available beds than homeless people on the street on any given night, then the law was said to be constitutional. But if the available beds, meaning those that an individual could stay out without any sort of restrictions like no alcohol use, no religious affiliation, things like that, were less than the number of homeless, then the law at that given time would be unconstitutional under the Cruel and Unusual Punishment. Well, the Supreme Court overturned Martin. The Supreme Court said that the Eighth Amendment is only related to punishments, not to whether or not cities may make certain activities criminal. The court was very aware of the challenges that cities have in dealing with homeless encampments, and the necessity to have a wide array of tools to be able to use and to address the homeless population. The dissent came across as saying, well, this case gives cities the right to now do whatever they want. It gives them unfettered discretion to punish homeless individuals. And the majority fought back on that idea and said, well, no, the case supports the idea that cities have leeway to use tools to help them with homeless populations, but that doesn't mean that all of the other constitutional protections given to the homeless are then out the window, and can still be used as a basis for unconstitutional enforcement. And just I don't think that this would ever come up, but Martin did mention and Robinson in that case that two different cases in this Grants Pass case, that it would be unlawful and unconstitutional to base someone's status as criminal. And so any criminal laws that you may have, or any ordinances that you may have, can't punish someone for their status. It has to be punishment for an act that they are doing, such as camping, or much like what Grants Pass had. The key takeaways are this: ordinances against public camping don't violate the Eighth Amendment. When drafting homeless ordinances, try to work with your homeless population to resolve the issues, and I think all of us are trying our very hardest. There's no simple solution. So this resolves any ambiguities, whether a city has the ability to use those tools or array of tools to address those encampments. The next case is in Muldrow v. City of St. Louis, and this is an HR case for your HR directors. In this case, a new police commissioner transferred, who was in the intelligence division, transferred and cleaned out a lot of the staff in his division. And 5 women and 17 men were transferred. And one of those women sued the city over the transfer, claiming discrimination because of her sex. And after the transfer, she had kept her same pay and rank along with her supervisory role, but she complained that she had lost benefits related to her schedule or her associations, her security credentials, FBI credentials, and other benefits that were taken away from her. And so the court evaluated the law that she sued under. Here it says, and bear with me, I'm going to read it here. It shall be unlawful employment practice for an employer to fail or refuse to hire or to discharge any individual or otherwise to discriminate against any individual with respect to his compensation. And here's the key words: terms, conditions, or privileges of employment because of such individual's race, color, religion, sex, or national origin. The district court and the Eighth Circuit Court of Appeals said, calm down. It's not that bad. It's got to be more than just those things that you're saying were taken from you. Minor changes aren't enough. It's got to be materially significant disadvantage. Otherwise, you don't have an adverse employment action. The Supreme Court said, I don't see it anywhere in Title VII's text where it says that. And so although many cases have been decided on a heightened bar for employment cases, discrimination cases, the court clarified that. And the key takeaways here is that talk to your attorney before any transfers, layoffs, terminations, reductions in benefits. I think that this significantly lowers the bar to file a claim of discrimination. And it's really important to train managers and supervisors how to do discipline. And I guess that's unrelated to this semi-unrelated to this case, but it plays into knowing that there's documentation of why those transfers, layoffs, terminations, rifts happened. The next case is Sheetz v. El Dorado County. Now, this looks like a pretty nice house. Would you be willing to pay $23,000 in impact fees to build it, though? And impact fees are what this is about. So Sheetz wanted to build this prefabricated home on his property. He went to get a building permit. They said you've got to pay $23,000 in traffic impact fees, and these impact fees were based upon a program recently passed by that legislative body, trying to make up for traffic infrastructure, and were pretty much unrelated to those specific developments, but everyone had to pay these traffic impact fees, regardless of how much or how little impact. He paid out of protest and then sued the county. His argument was that the impact fee charged was not connected to the project and did not represent the impact that his home would have on the overall system. And frankly, the city's argument was really odd. They argued that the Nolan-Dolan test, which I'll explain in just a minute here, did not apply to legislative acts, and because the impact fees were determined through a legislative act, an adopted legislative act, that Nolan and Dolan didn't apply. So the Nolan-Dolan test is that impact fees comes from two different cases in the past, and has been around for quite some time, where it says that the impact fees have to be tied to the development that is going to be built, and that the amount of impact fees must be roughly proportional to the impact of the costs upon the city system and capital infrastructure. Excuse me. And so the court looked at this question and said, well, the Nolan-Dolan test applies regardless of whether it's an administrative act or whether it's a legislative act. It doesn't matter. It still applies regardless of where it comes from, whether it's on it was developed in a department level or whether it was legislative. So it's a narrow case, but a few things that are a little bit concerning in the opinion was that one of the opinions said, we're not deciding, although we may in the future decide whether put the question up to whether the impact fee study should be on a case-by-case basis versus a broader net developed under an impact fee study, or whether cities would need to essentially a development by development impact fee study. It's really what it comes down to. And whether cities would need to start tracking the actual dollars from impact fees and tracking exactly whether they were related to a certain development or not. So it was a narrow decision, but it is one thing that is on the interim agenda that is to be discussed this interim before the legislative session. The The next, so yeah, just like I said, just be on the watch for any certain legislation on impact fees that may come up. This odd slide, and I know Cassidy in our office is just killing me for it. She loves it. This case is not about Chevron pattern, nor is it about the gas station. It comes from a case, and the Chevron doctrine is where it says courts should defer to an agency's interpretation of the law if that law is considered as a whole as ambiguous, so long as the interpretation is reasonable. It's been used in thousands of cases as the court's logic as deferring to an agency's interpretation of a particular law. And so the facts of this case, a fishing expedition company were forced by the National Marine Fisheries Service, who is the federal agency in charge of enforcing and administering the Magnuson-Stevens Act. The act was put in place to make sure the fishing off the coast of the United States were managed by the government. And this agency came out with a new rule that required each of the fishing expeditions to pay for an observer, someone that would stand on the boat and pay the whole time that they were out fishing to manage basically to babysit these fishing expeditions. But the payment was to be made by the fishing expedition. And the fishing expedition sued, stating that the MSA, the act, didn't require that they pay for this observer to stand on deck, and that the rule was arbitrary and capricious under the Administrative Procedures Act. And so the agency said, well, we believe that it does give us that authority. When taken to the appeals court, they said, well, we think, even though it was silent in the act about payment for these observers, the appellate court said, well, we still think that it was clear that the fishing expeditions should pay, and even if we aren't right on that, it comes back to the Chevron doctrine, which we're pushing that to. We think that we've got to push that back to the agency's interpretation that, yes, they do have to pay for this observer to stand on deck, pay $170 per day. And so the Supreme Court instead said they overruled Chevron and said that courts must exercise their independent judgment in deciding whether an agency has acted within its statutory authority. The key takeaways here is it really has far-reaching impacts given the amount of federal regulations and federal agencies and other agencies. So this is it's not certain, though, how this is going to affect local governments. I could see it going both ways. We win some and lose some based upon bad agency interpretations. And vice versa, our interpretations. So the next case is about bribery or gifts, whichever one you think is applicable here. For those of you who may have trouble seeing this, the small print says, bribery is such a dirty word, don't you think? Let's just call it a gift from you to me. So, the facts in this case are that the City of Portage awards lucrative contracts to a local truck company called Great Lakes Peterbilt. The year after the contracts were awarded, the mayor of Portage received a healthy check for $13,000. And he said, well, no, this isn't a bribery. This isn't a payment. It's for his consulting services. Well, federal prosecutors charged Snyder with violating that federal bribery law, and he was convicted at the district court level and sentenced for a year and 9 months prison sentence. And so the issue in this case is whether the federal law makes it a federal crime for state and local officials to access gratuities for their past official acts, making a difference here between a distinction here between bribery and gratuities. They focused on the words influence or reward, and the Supreme Court said, you know what, gifts, they're okay. Nothing wrong with that under this statute. It's only when you take it as a condition of a public act that you're going to get in trouble under this act. And so it's a little bit of an odd decision. I think it was more of a statutory interpretation case, but beware. This doesn't mean that accepting gifts are now okay without these parameters. This is in state code, Utah Code 67-16-5, and encourage you to look at that. My standard is when in doubt, don't. But some of you may want to do an interpretive dance, and that is okay. But I think that it would help to ask your attorney to see their thoughts on, if someone invites you to a jazz game or someone, what their thoughts are on that. Ultimately, it would be your decision as a public official to decide what to do with that one way or another. The key takeaways here is just because the court said that Section 666, which I find ironic, does not apply to local public officials receiving gifts, the state of Utah still regulates that activity. Make sure that conflict of interest forms are signed and that you've got clear policies regarding gifts and what can and can't be received. The next case, the last case before kind of a shotgun approach, is that there was a jewelry owner who bought a stolen ring for $45. It was valued at much more than that. And once the owners heard word that the ring had been stolen, they got the police involved, and Chiaverini said that he wouldn't give the ring back. And during the middle of the investigation, why you would admit this, not sure, but he said, well, yeah, I don't have a license to run a jewelry business. So he was charged with 2 misdemeanors and a felony. The prosecutors seemed too busy to follow up on procedures, and the case was dismissed because they didn't present it to the grand jury in time. So instead of letting it lie and being done with the case, Chiaverini filed a malicious prosecution against under a 1983 act. And his argument was that the Fourth Amendment, they had no right to prosecute him because he didn't have probable cause on all of the charges, only some. So that was basically the issue. Can a lack of or the presence of probable cause of at least one other charge automatically defeat a Fourth Amendment malicious prosecution claim when there are other charges that did not have probable cause? The answer simply was no. You need to have probable cause on all of them, and if not, you can still proceed forward on the malicious prosecution case. The next ones I'm going to actually skip so that we can look at these questions. The last ones are just holdings, and I didn't find them very applicable, so I'll let you look at those slides at the end. The first one of the first questions is from Josh Collins. Going back up to the social media platforms, do you think municipalities can and should limit social media posts so that no one can comment on the municipality's posts? Said another way, can and should municipalities turn off comments as an option on all social media platforms? Do I think that that would be a good practice? Yes, I do. I don't think that you'll run into as many problems as you otherwise would at all if those were simply blocked off from commenting altogether. Because there are so many responses that are wanting to be given, or offensive comments that can start issues if you delete or altogether block. Yes, I would say yes. To Matt Dixon's question, for the Loper Bright v. Raimondo case, would this be applicable to discussions happening in Utah relating to regulating housing deed restrictions? There's discussions about requiring developers to pay for the enforcement of deed restrictions on housing projects in cities. What are your thoughts? Well, so I think that there's a difference between what you're saying here and what the issues were in Loper. In Loper, it was mainly discussing the agency's interpretation of a law written by Congress, the legislative body. And so if there is legislation that is run that says, look, developers have to pay for the enforcement of deed restrictions on housing projects in cities, then that would be a legislative that would be straightforward and being able to be followed. That there wouldn't be necessarily any agency interpretations. So I don't think that would apply in that specific scenario to Loper, although I would be in favor of that idea. The next question, Tom Hansen, if you have time, free speech question. When broadcasting council meeting on YouTube, are we required to allow for public comment on the broadcast? Do we have to allow public, or do we have to allow comment? I would say, without looking at it in detail based on that question, I would say you are acting as an anchor location for public comment. And because if you open the doors to public comment for, say, a 3-minute period, and you're opening it up to those that are not, or opening it up to those that are there present, you should also be opening it up to those online. That's my off the cuff, without getting down into the nitty gritty response. I think that if you've opened it up for online viewing, and you've also established that there's a 3-minute public comment period, then that should also be opened up for those that are listening in through electronic means. The other Todd said no on the public comment question. So what if I don't like your answer? Let me go back to this disclaimer. I think that if you just follow what your attorney says, I don't know what city you're from, Tom, but follow what your attorney says and you'll be in good hands, I'm sure. And to say this, 3 minutes over, so maybe I'll just cut the other Todd Sharon out. No, I'm just kidding. If a person bought a lot in a 40-year-old subdivision, man, you've got to have a hypothetical like this. If a person bought a lot in a 40-year subdivision that is 90% built out, would that home really need to pay the standard impact fees when development of this type of lot would not have a very big impact to the system since it has been around for 40 years? Based on the Sheetz decision, I think a person could make the same taking argument. And can you get me a Dr. Pepper? Yes, I think that I think they could make the same taking argument, which in my mind is why it's so whether they would win or not, I'm not sure. I think it's so important to update your impact fee studies on a regular basis and not have 7-year-old impact fee studies that you're not collecting the total amount because it changes, and so you've got to respond to that. It's going to be different 40 years down the road, and if you're already behind on your impact fee study, they need to be updated. So with that, seeing no other questions, as a reminder, we will make available the recording of this webinar and the slides as well.